The weight of the law 11:47 p.m. The road rain. Headlights smearing across wet asphalt. Professor Daniel Algren's hands sit loose on the wheel, too loose for a man driving in a storm. A half-empty bottle rolls against his ankle on the floor mat. The radio hums something he isn't listening to. A figure steps off the curb. Small. An umbrella too big for the body holding it. Daniel's eyes are on his phone, propped against the dash, glowing with an email he's drafting to the dean. The umbrella tips. Impact. The car shudders. Someone rolls across the hood and disappears into the dark beside the road. The radio keeps playing. Rain keeps falling. Daniel's hands are frozen on the wheel 10 and 2 like he's still being graded on his form. 11:48 p.m. The choice: he doesn't stop the car so much as the car stops itself, rolling to a halt 50 feet past the spot, engine idling, wipers ticking back and forth like a metronome counting down something. Daniel stares into the rearview mirror. Nothing back there but rain and red taillight glow on wet road. He should get out. He knows the statute, duty to render aid. He has taught it for 14 years. Section after section recited to rows of 19-year-olds who took notes like it was gospel. His hand finds the door handle. Stops. He looks at the bottle on the floor. Looks at his phone, still glowing with the unsent email ray. Tenure committee review. He puts the car in drive. The next morning, lecture hall 204, Professor Algren stands at the podium in a pressed shirt, hair combed, eyes only faintly red, explainable, he's decided, by a poor night's sleep. 80 students wait, laptops open. On the projector behind him, TORTSII, negligence and causation. Negligence, he says, voice steady, practiced, requires 4 elements: duty, breach, causation, damages. He writes them on the board, the chalk clicking with each letter. Today we'll discuss what happens when someone breaches a duty of care and runs. A few students laugh softly at the word choice. He doesn't. In the third row, a student named Priya Khatri glances at her phone under the desk. A local news alert just pushed. Child struck by vehicle on Elm Street. Driver fled scene. Police seeking witnesses. She looks up at the front of the room. At her professor's hands, gripping the chalk a little too tightly. That afternoon, the dean's office, a hit and run, the dean says, sliding a printed article across the desk. 6 years old, critical condition. Witnesses say a dark sedan. He looks up. You drive a dark sedan, Daniel. So does half this city, Daniel says. His voice doesn't shake. He has spent a career training it not to. The dean studies him a long moment. I know, he finally says. I'm only telling you because the police will probably canvass faculty parking. Just be ready for questions. Daniel nods, stands, shakes the dean's hand. His palm is dry. He has rehearsed this exact gesture in his bathroom mirror at 6 that morning. 3 days later, the body shop a man in coveralls runs a gloved finger along the dented hood of Daniel's sedan. A spiderweb crack in the headlight glass. A faint smear long since wiped, but the dent remembers what the paint forgot. Dear, Daniel says again, the same word he used on the phone. Hit it on the county road. Mechanic doesn't answer right away. He's seen deer damage. He's also seen this kind. He says nothing, not yet, but he photographs the dent before buffing it out. Force of habit, or instinct. 1 week later, lecture hall 204, causation, Daniel says, chalk in hand, is the hardest element to prove. A defendant may owe a duty. He may have breached it. His voice catches just slightly on the word breached. But if the plaintiff cannot tie that breach directly to the harm, the case collapses. Priya raises her hand. What if the defendant destroys the evidence that would prove it? A pause, too long. Daniel sets the chalk down. Then, he says, the law has other tools: spoliation, adverse inference. He looks directly at her. But evidence has a way of surviving, Ms. Khatri, even when people don't want it to. Room is silent. Several students glance between the two of them, sensing something they can't name. 2 weeks later, a dorm room. Priya and 3 classmates sit around a laptop. On the screen, a grainy traffic camera still, time-stamped 11:47 p.m., 3 blocks from Elm Street. A dark sedan, partial plate visible, 3 characters clear, the rest blurred by rain. It's not enough, says Marcus, the one who pulled the footage through a public records request. 3 characters could match 1,000 cars. It's enough to check faculty parking, Priya says. We're not the police. We don't need proof beyond reasonable doubt. She looks up. We need probable cause to ask one question. Nobody speaks. The rain ticks against the dorm window, the same rain, it seems, that never quite stopped since that night. The confrontation, faculty parking, garage dusk. Daniel walks toward his car, briefcase in hand, mind already on tomorrow's exam questions. 4 shapes step out from between the concrete pillars. He stops walking. Professor Algren. Priya's voice doesn't waver, though her hands, jammed in her coat pockets, are shaking. We pulled the traffic cam footage from Elm Street. Partial plate match. Right model, right color, right night. The repair shop, Marcus adds. They photograph everything before a buff job. We have a date-stamped picture of your headlight cracked, the same week as the accident. Daniel's briefcase slips slightly in his grip. For one single second, the practiced calm cracks, then resets, making a very serious accusation, he says, with circumstantial evidence that wouldn't survive a motion to dismiss. No, Priya says quietly. That's why we're not the ones filing it. Behind the pillar, a 5th figure steps forward, badge already in hand. A detective who has been listening the entire time. The interrogation room, fluorescent light. A steel table. Daniel sits with his hands folded the way he folds them at the podium, composed, lecturing posture. Even now, we have the plate, the detective says. We have the body shop photo. We have a witness who saw a car matching yours leaving the scene without stopping. A pause. What we don't have yet is you. Daniel stares at the table. 14 years of teaching students that the law exists to protect the innocent. 14 years never once asking himself what happens when the law comes looking for the guilty and finds him. I didn't see her, he finally says, voice cracking on a register his students have never heard. I didn't see her until he stops, starts again. I was going to call when I got home and you didn't, the detective says. Not cruel, just true. Daniel's hands, folded so carefully, begin to shake. I taught duty to render aid for 14 years, he whispers. 14 years. Verdict. 6 months later, the courtroom is full. Faculty in the back rows. Students, Priya, Marcus, the others in the gallery, close enough to see Daniel's face when the jury foreman stands. On the charge of vehicular manslaughter, guilty. The charge of leaving the scene of an accident, guilty. The charge of evidence tampering, guilty. Daniel doesn't move, doesn't speak. The man who once stood at a podium reciting the 4 elements of negligence sits now in the place where those elements are no longer academic, where breach and causation and damages have names, have faces, have a small umbrella that was found 3 days later, crushed, in a storm drain 2 blocks from Elm Street. The judge's gavel falls once. The sound fills the room the way chalk on a blackboard once did, small, final, absolute. Lecture Hall 204. 1 year later, a new professor stands at the same podium. Different voice, same chalk, same 4 words written on the board: duty, breach, causation, damages. In the 3rd row, Priya, now in her final year, doesn't take notes. She already knows this lecture by heart. She learned it somewhere a transcript can't reach. Law, the new professor says, does not care who teaches it. It does not care who breaks it. It is patient. It waits. And eventually, she lets the sentence hang, the way a verdict hangs before it's read. It finds you. Chalk clicks against the board one last time, underlining the final word.